elders past and present. May I also extend a warm welcome to the many distinguished guests here tonight. I acknowledge the presence of judges and registrars of the many courts, including the Court of Appeal, the Supreme Court of Western Australia, the Family Court, District Court and Magistrates Court, the Director of Public Prosecutions, Mr Robert Owen SC, the President of the WA Bar Association, Mr Brahma Dharmananda SC, and all members of the profession. It is also my particular pleasure to welcome Miss Eve Burt, the granddaughter of the late Sir Francis Burt, and to acknowledge the daughters of Sir Francis Burt, Sue O'Connor and Janine Milton, and his son Marcus Burt, who are unfortunately unable to attend this year's oration. Sir Francis was, of course, a trailblazer within the legal profession. He was admitted to practice in 1941 and took silk in 1959. He was appointed as a Justice of the Supreme Court of Western Australia in 1969, a position that he held until 1977, when he became the 11th Chief Justice of this state, a position from which he retired in 1988. In early 1961, Sir Francis commenced practising solely as a barrister. In doing so, he became the founder of the independent bar in Western Australia. The chambers he founded are now known as Francis Burt Chambers in his honour. And this evening, we are delighted to have the former Chief Justice of the Federal Court, the Honourable James Allsop, as our guest speaker. The former Chief Justice, of course, requires no introduction. But in keeping with the subject matter of tonight's oration, I was interested to see how AI considered our speaker and this topic should be introduced. I input the following request. Well, actually, in truth, and perhaps as a reflection of my own lack of advancement, I texted my teenage son and asked him to input the following request. Write me an introduction for the former Chief Justice of the Federal Court on an oration about the legal system and the administration of justice in a time of technological change, machines becoming human or humans becoming machines. Just seconds later, a 1.5 minute introduction was texted to me, and you are all welcome to come to see the content of that in due course. But along with the text, I was sent a disclaimer from my son. His disclaimer went, "Please don't trust any info ChatGPT gives you about this guy. He's not famous enough." I won't take you through the detail of what ChatGPT said to me. I'm sure you're all here to listen to the Honourable James Allsop and not me. But my observation is that what it sent back contained too many adjectives, felt impersonal, lacked depth, and indeed reworded the question, presumably by use of a thesaurus-type tool, such that it changed the meaning of the question. But perhaps more importantly was the observation from my son that it was not to be trusted. Hopefully that means, at least for the immediate future, that there remains a place for us mere mortals in the law. On that note, and to shed some light on that topic, may I invite the Honourable James Allsop to share his thoughts and ask you to welcome him in the usual way.
I too acknowledge the traditional custodians of the land on which we gather, the Whadjuk people of the Noongar Nation, and pay my respects to their elders past and present. And it's a great honour to be asked to deliver this oration, bearing the name of a great Chief Justice and a great judge, and the inspiration for the bar in Western Australia. And I'm particularly pleased to be able to deliver the oration in the presence of the late Sir Francis's granddaughter Eve. I should apologise to some in the audience. I've apologised to a couple already. They may have heard some of the refrains from the later symphony this evening. My topic tonight, I hope, does not evoke images of machines and a deracinated future. Much of the superficial and some of the not so superficial public discussion on the topic takes us to places where science fiction would have not long ago reigned. I thought that old folk would shake their heads hopelessly, fearing the future of a lost, sensible path, whilst young folk with a less fearful approach to technology would see excitement in a new world, but often perhaps without asking themselves some of the basal questions about the human dimension of the changes. But in fact, there is some research to show that the most enthusiastic are the 50 to 60-year-olds, presumably of that grey-haired, tech-savvy, hip persuasion, eager to stay ahead of the ever-increasing velocity of time, while the younger generation, having grown up with the technology, are more cynical of its proclaimed advantages. And perhaps Kim's son is illustrative of that. My topic is technology in the law and the administration of justice. That is, law and justice, being the elements of a just society bound together for millennia as the intertwined fabric of democratic free society. This has been so whether the free democratic polity was in a limited form, as in ancient Athens or Republican Rome, built on slavery, or the new Republic of the United States, built at least in part on slavery, or in a nascently wider form in England and Europe in the struggle from absolutist monarchy, monarchical power from the 17th century. Law and justice are immanent within ordered civil societies and frame and protect free societies. They are not separate integers of a mechanism built on logic and words alone. They are part of the one whole. If one conceives of law as the rules, principles and precepts of social and societal organisation built on the values of society, one can see law as organised morality. The COVID pandemic put great strain upon the administration of justice. The physical places of courts and courtrooms were closed and inaccessible. This was a deep impediment to the hearing of cases which required physical presence of the actors in one place, in particular criminal jury cases. But technology, albeit well-known technology available for decades, apart from the digital mechanism, properly organised and utilised, allowed courts to continue to hear almost all other cases, with the participants dispersed and located sometimes in their homes and offices. The ability to put in place and maintain this dispersed system of justice gave many insights. That a court could systemically continue to operate using digital technology for communication, that access to justice could be given to people in remote locations, that disadvantage of those without resources could be overcome by the court itself providing communication facilities in its premises, and many other insights. The insights were always born of the lived experience of the use of the technology and of the thoughtful contemplation of that use and experience. The central importance of the state taking all litigants seriously in the way that technology was made available. The necessity for acceptance by the users, the litigants, that this was a proper and respectful manifestation of just state power. That the judge and counsel were who they and the circumstances represented them to be, the essential actors in a real performance of the execution of protective state power by a human but detached, abstracted in that sense, delegate of the state. How this balance between in-person and remote hearings is resolved in the future will also be a matter of lived experience, in the recognised necessity of maintaining confidence in the administration of justice for its fairness, dispatch, efficiency and humanity. Whilst physical presence is important, it is not necessarily universally demanded. The role that the thoughtful and energetic use of available technology played in overcoming a significant challenge to the capacity of the courts to function should not be forgotten. But tonight I wish to direct myself to the likely transformative changes to our lives, the law and the administration of justice by digital technology and artificial intelligence. I have mentioned our shared experience of the pandemic to introduce a number of considerations that should be kept near as we discuss these developments that are startling in their capacity to herald change. Law and justice, the protective character of judicial power, its consensual foundation built on confidence in the administration of justice, the necessary human character of the law and the administration of justice through the interwoven antinomies of abstraction and human experience. The judge as the detached and in that sense abstracted representation of state power, but as human, fallible and dutiful. The process of justice being perceived as infused with humanity and in which confidence and consent are placed. These digital and AI technologies and capacities are, of course, not matters that are limited to the law. They will change the whole of society, human and social relationships, and perhaps even our consciousness and sense of humanity. None of these things is definable or predictable. We need to be careful of definition and prescription and of overconfident prediction in this field. I cannot give you a comprehensive expression of the digital and AI challenges that we are facing, but I will say a little about AI itself, not to make you better informed about AI, but to contemplate how it may affect the legal system and the administration of justice. There are probably other more pressing considerations about AI, such as how it will affect man's capacity to develop and use murderous weapons of war, or cyber invasion. Nevertheless, how the administration of justice as the foundation of a free and civil society will or may be affected is certainly a subject worthy of some contemplation and discussion. It is helpful first to consider the vastness of digital information in its electronic form that is publicly available and that can be reached by computers. Even in a restricted field such as the legal system, the available digital recorded information is vast, written in different languages, but nevertheless written. Take our domestic legal environment. The now vast availability of legal precedent, the size of statutes and regulations, and the digital multiplication of communication and records almost demand assistance from optical character recognition and analysis by AI. We have, through digital technology, already created a mass of information which is sometimes incapable of human analysis, let alone even reading, in a short period of time. So what is AI that I wish to discuss? The kinds of AI systems to be considered are called artificial neural networks, an example of machine learning, where vast bodies of data are examined or read for correlations and patterns, perhaps mimicking in a learning process how the brain works, perhaps setting out on their own course. This is a subject of some interest. Certain systems are designed to work without human supervision and instruction. There is a degree of inexplicability. Nevertheless, ultimately, it is a form of information processing. The layers of AI systems, not sure where this goes actually. The layers of AI systems are the processes that join the dots between input and output. It is possible to establish parameters and principles that guide the processes, and at least in part to reconstruct what the machine has done to arrive at its conclusion. But there is a real sense in which the processes admit of no elaboration in logical terms, somewhat like quantum mechanics. At this point, it should be remarked that the information for AI to work upon must be written and recorded in expression. That is both a statement of the obvious and a hint of more profound considerations. Is the totality of written knowledge all knowledge? If knowledge cannot be written down, is it knowledge? I would hope that you here would answer those questions no and yes, respectively, even allowing for the inadequacy and ambiguity in the word knowledge. The notion that all knowledge or information can be written down is absurd. Important concepts, feelings, emotions, and the implicit can lie between the written word, and meaning often lies hidden in the shape of ideas, in the connotation and the implicit, including the implicit metaphor, and in the uncertain context of life. It is also important to recall that all knowledge, information, and data that AI is examining is existing or past. The layers between artificial neural networks that transmit data from input to output deal in algebra, algorithm, and probability. Large language models develop their own vocabulary using numbers, wherein natural language, words, and parts of words are assigned numbers or tokens. ChatGPT has a vocabulary of 50,257 tokens. Through machine learning, the machine is fed data which it detects and graphs patterns. The data is vast. The machine learning can be supervised, unsupervised, or reinforced. It's beyond my ability to understand beyond general expression how all this is done, but it is sufficient to recognise what can apparently be done. Most importantly, by reference to all data available on the internet and prioritised data available in defined sets of data and information, tasks can be requested, and not only searches made through recognition of the presence of data, thus searching and retrieving, but tasks of apparent analysis of the bodies of data and expressions of conclusions by reference to questions asked. Thus, analysis of written information can be undertaken by the machine, which involves the search for, reading and analysis of, and conclusions drawn from vast bodies of data, together with any prioritised cohorts of data, to produce an analytical answer in a tiny fraction of the time a human or many humans could execute the task. These possibilities engender, or I think should engender, excitement and hope for our legal system. If large bodies, volumes of data are able not only to be read and organised by machines, but in some form critically analysed by pattern recognition and mimicking of the human brain in functional process or result, Large tasks of data processing can be undertaken swiftly and at little cost. This presents a potential radical change to a legal system, a true inflection point. It is already a reality. eBay and other e-commerce providers and intermediaries are already providing AI dispute resolution. Given the volume and value of most sales on such platforms, this is not replacing any system of dispute resolution. Rather, it is creating one and provides the only possible system of dispute resolution. There exist now legal products being used aimed at substantive law solutions that provide legal services by performing legal tasks, targeted at lay as well as professional users. These kinds of tools should not be left to the private sphere. If public justice is to remain relevant, it must incorporate and give confidence and validity to these tools to improve access to justice. For instance, the Singapore Legal Aid Bureau has developed a chatbot to provide information on family and civil disputes. These kinds of technologies permit or facilitate the growth of alternative legal service providers, helping parties create documents and examine and answer questions about large volumes of data and information. The speed, growing accuracy and lowering cost of large data analysis will have an effect on all aspects of legal practice. A redefinition of what is skilled human legal work, what legal work can be commoditised by automation, how legal work can be reorganised leading to different roles. The first and most obvious of such new roles is the coming together of computer engineering and legal skills into the same people in their education and in their practice. The tasks of junior and senior lawyers will change. Professor Susskind in Tomorrow's Lawyers sees new roles of the legal data scientist, managing and analysing legal data, and the legal knowledge engineer, who, he says, will translate legal principle and precedent into code. This last point, translating legal principle into code, raises profound questions about the law and society, to which I will come shortly. Generative AI, which can generate new content in text, image and music, is in use today with such tools as Harvey and Co-Counsel, which are in use by lawyers as we speak, preparing drafts of documents, producing research briefs, and reviewing and analysing contracts. There is no doubt that legal research and the production of some legal documents, or at least drafts of them, will be more and more done by generative AI. GPT-4 is said to be able to pass the US Uniform Bar Examination, at least the multiple choice paper, at a higher average than the average human test taker. And it can pass the legal essay and problem-solving test. There is undoubtedly a challenge for the courts here. The courts must engage with these tools of undertaking legal analysis, in particular where the utilisation could facilitate access to justice for litigants. In a world of vast bodies of data, sometimes expressed in language of impenetrable prolixity, ascertaining the barest outline of the framework of one's rights, let alone an assessment of their likely character, can be, and often is, time-consuming and prohibitively expensive. If the courts, in partnership with respected AI providers, could provide information and analytical apps to litigants. This would open up to large numbers of people a low-cost way of ascertaining, at least to some measure of satisfaction, what their rights are or may be and how they might deal with them. This may, and perhaps will, involve a broadening of the role of the courts from decision maker to facilitator of access to justice. It may involve more resources. It may involve a reconsideration or reconsideration of how to engage with the public and the profession. However, if it is not done, the role will be played by external actors, and the courts will lose a measure of control over and relevance for a growing sector of the administration of justice. They may become marginalised in a world of unregulated, machine-generated answers to questions and disputes. When I was Chief Justice of the Federal Court, my then CEO, Mr Warwick Soden, and I were considering exploring such partnerships. COVID intervened and attention was diverted elsewhere. COVID, in this respect, impeded technological development. The Singapore courts have begun such partnerships. Other courts may well have done so also. I know from visits some years ago that the Chinese courts have used AI to oversee judgment writing for some years. The scope of this task is one for the consideration by the Australian Academy of Law and the Australian Institute of Judicial Administration. But for the purposes of tonight, let's not talk about AI today in its infancy. Let's just hypothesise a perfect AI. Let us assume that in respect of subjects and problems, or parts of subjects and problems that are amenable to logical binary analysis by reference to large bodies of data, AI will be able to produce an accurate or correct conclusion. Let us also assume that aspects of legal work requiring creativity, emotional intuition, evaluative judgment, and social intelligence can be or will be able to be mimicked by the AI machine. It is at this point that it is necessary to say something of what law and justice is or are. To do this, I will seek first not to theorise, but to explain by experience. What engenders loyalty, the loyalty of society in the law, judges and courts? Is it accuracy? Is it consistency? No, not wholly, though these are not irrelevant considerations, obviously. What engenders loyalty is an indefinable mixture of the law, with its rules, principles and values, and the dutiful undertaking of the task or process of examining the problem or dispute and applying the law to the context and circumstances with diligence, care and intelligence in a fair and impartial way, and which recognises the dignity and humanity of the people before the court. The importance is not just in what is done, but how it is done. This process is both intensely human and analytical. It is both abstracted and experiential. It reflects a social or human bond between the state and citizen. Let me give you 3 examples of the indefinable humanity of the law and the intertwining of the law, of conscientiously undertaken duty, of theory and of human values. First, one of the greatest of Australia's legal scholars and judges died this year, far too young, Paul Finn. He was a generous and kind colleague who was capable of challenging the intellect. He, like all of us on the federal court in the 1990s and 2000s, had the task of dealing with a great many immigration cases, often hopeless in law, but always replete with human hopes, fears, and often with suffering. The gentle and evocative obituary by Professor Tim Boni-Hadie, that was published in the Financial Review, recorded the words of an Iranian applicant who came before Paul. He said, "It does not matter to me if I win or lose, as I sense that the judge is a spiritual man who treated me with such respect that he will do what is right." It was the human recognition of Paul's dutiful engagement in the task, in the process, that revealed to this man, with his insight, that something deep and important had taken place in his experience with and of Paul. This is not imagined. It is the social bond of justice being manifested among and recognised by humans who come together in an act of supplication and request before state power and authority. It is a bond that is achieved not by a correct result, but by the engagement of the fallible human in the task of ascertaining and applying the law in a detailed and abstract way, and by the respect shown to the dignity of the parties. The imminent antinomies of individual humanity and abstracted rule and principle, built on and derived from the human experiences of the dutiful judge engaging in the task, in the process, and the perception of the same by the litigant, communicated something to this man which process cannot be mimicked electronically in or by a machine, even if the machine may derive the exact same result or answer as the human judge. This man had the poetic gift to express it. Many litigants feel the same thing, even if they do not conceptualise it or express it in language. The experience emotes a feeling that is most often not expressed, that justice has been done. The second example further illustrates the same point. Some years ago, a judicial colleague presided over a most distressing murder trial at Taylor Square in Darlinghurst, in Sydney. The venue of the trial is relevant because after 5 p.m. on court sitting days, there was no security staff to open the heavy iron gates to permit egress by a judge if he or she had a car. The accused was a man who had stabbed his transgender partner to death in a violent domestic rage. They had met in prison. The relationship was at times tense, at times loving. On the day in question, the accused had become enraged by being taunted by the victim about his sexuality and manhood. The families of the victim and the accused were present during the trial. Neither was a sophisticated group of people. Neither apparently well educated, both apparently of modest means, and each with an air of the capacity to intimidate. There was, however, never any form of misbehaviour in court, though at times there was displayed a certain brooding and barely suppressed emotion as some of the evidence fell out. The accused's family had not been aware of the relationship between victim and accused. The trial was run by the judge with a gentle but firm command, in a clear voice, but with evident compassion and fairness. After some days of hearing and deliberation, and late in the afternoon, The jury convicted the accused, who was then remanded in custody as the offender. Not long after, in the fading light at 5 p.m, after 5 p.m, the judge was grappling with the padlock on the gate. She noticed, a matter of yards away, the family of the now offender. They were obviously distraught and agitated. One, a sizable young man, probably a brother of the convicted accused, stood and looked at the judge. After a time, he appeared to recognise, despite the absence of the camouflage of wig and red robes, the judge who had just presided over the trial, a catastrophic chapter in their lives and in the life of their son and brother. The young man who had noticed the judge nudged and spoke to the others. They turned, fell silent, and looked at the judge. Nothing was said, but the young man and one or more of the family nodded to the judge in apparent recognition of who she was and in apparent acceptance of the fate that had come to them and to their son and brother. This was a silent and deeply emotional acceptance of the fairness and humanity of the process and of the person who had presided over it. These people did not have the eloquence of the Iranian man before Paul Finn, but their appreciation of the presence of justice was just as profound. The third example was a case that had a deep effect on me as a judge, midway through my judicial career, when I began to think deeply about the criminal law, presiding in the Court of Criminal Appeal. This was a case well known to many of you, Veen number 2. In 1971, Mr Veen, a young man aged 20 years, was convicted of manslaughter, having viciously stabbed his victim many times. He had a formidable criminal record, including maliciously wounding his landlady 4 years previously in an attack with a kitchen knife. He had attempted suicide on a number of occasions. The evidence of his diminished responsibility was given by a psychiatrist but was unsatisfactory. But what was clear was that he had a long history of alcohol and drug abuse as a child and teenager and had suffered physical and sexual abuse as a child. Mr Veen had been working as a male prostitute, and after having spent the weekend with the client victim, whom he had met on the Friday evening at King's Cross, he violently stabbed the man after drinking heavily and being subjected to racial abuse. He was sentenced to life imprisonment. The sentencing judge said that the ordinary sentencing principles did not apply and that he had to be imprisoned to protect the community. The Court of Criminal Appeal dismissed the appeal. The High Court, by majority, allowed the appeal and the matter was remitted for resentencing. 9 years later, in 1988, Mr Veen came before the High Court again. He had been released on licence on the 20th of January 1983 for the earlier manslaughter after resentencing. On the 27th of October 1983, 9 months later, he killed another man, again by stabbing repeatedly. The victim was also a client of Mr Veen, who had again been working as a prostitute. A plea of manslaughter was accepted on the basis of diminished responsibility. Again, he was sentenced to life imprisonment. The psychiatric evidence was more cogent on this occasion as to his propensity for violent conduct. Again, the Court of Criminal Appeal dismissed the appeal. This time, the High Court, by majority, dismissed the appeal. The reasons of the majority, Chief Justice Mason, Justice Brennan, Justice Dawson and Justice Toohey, are important in expressing the principle of proportionality in the law. The minority, Justice Wilson, Justice Dean and Justice Gaudron, in their respective judgments, would have allowed the appeal on the basis that the length of the sentence reflected a measure of preventative detention to protect society without statutory warrant. It is the reasoning of the majority that is of importance for this evening. The judgment has a sophisticated subtlety of the expressed and unexpressed, reflecting the true human character of, as well as the antinomies immanent in the conflicting considerations necessary for sentencing. The majority recognised that a sentence should not be increased beyond what is proportionate to the crime in order merely to extend the period of protection of society from the risk of recidivism on the part of the offender. However, they said that that did not mean that the protection of society was not a material factor in fixing a proportionate sentence. The majority observed that the practical observance of a distinction between extending a sentence merely to protect society and properly looking to society's protection in determining the appropriate or proportionate sentence called for a judgment of experience and discernment. I would interpolate human wisdom. The majority lucidly and with great humanity discussed the apparent anomaly in the way in which mental abnormality, which could make an offender a danger if he were at large, is regarded when it reduces the crime of murder to manslaughter. The mental abnormality of diminished responsibility exonerates an offender from liability for conviction for a more serious offence. But that exoneration having taken place may be a factor which sees a heavier punishment than might otherwise be the case. Sentencing was recognised as not purely a logical exercise, and the troublesome nature of the sentencing discretion arises in large measure from the unavoidable difficulty in giving weight to all the purposes of punishment. All the purposes overlap. None of the purposes can be considered in isolation from the others when determining what is appropriate. Sometimes the purposes point in different directions. Reading the whole judgment with all its lucid subtlety, one can conclude that it was the necessity to maintain public confidence in the processes of the criminal justice system that was of determinative importance. This is not a question of logic, it is a question of human judgment. The perfect AI machine might be able to mimic the result and perhaps the reasoning of and in the majority judgment, or the judgments of Justice Wilson, Justice Dean and Justice Gaudron. There was no correct conclusion in this case. The human values expressed by all of those great judges were moulded and shaped into different conclusions by humans dutifully attending to their task. The acceptance of one or other of the judgments is not by its correctness. It flows from the process of human engagement in the infliction of punishment on behalf of the state on the offender who comes before the court. To suggest that a machine undertake this task is to fail entirely to appreciate the necessity of human engagement. The capacity to mimic is irrelevant. These two events and one High Court judgment should now be placed in a framework of ideas. I will borrow from what I have said in the past, as I said at the beginning, for those who've heard an earlier refrain of some of these ideas. This is to assist in understanding why humans are integral to the law and the administration of justice, and not just the criminal law. That is not to reject or minimise the quite possible importance of AI in assisting in dealing with the thickets and forests of data that we have created in modern life and that threaten to choke the law and public administration. The poetic insight of Paul Finn's Iranian applicant and the intuitively generous and gentle recognition of justice by the distraught family of the offender at Taylor Square are not just expressions of human feeling or emotion. They help to illuminate the nature of the rule of law, a nature which, when appreciated, can be seen not only to accommodate, but also set the necessary limits for the enthusiastic use of AI. Dicey gave three meanings to the rule of law. First, that no one is to be punished except for a distinct breach of the law established in the ordinary legal manner before the ordinary courts. Two, no one is above the law, and everyone, whatever rank, is subject to the law and to the ordinary courts. And thirdly, which he took as peculiarly English, I doubt whether it is, a pervading legal spirit of freedom in the common law, rather than in constitutional conceptualisation, which he saw in foreign countries. It's the third meaning that is important for present purposes. The condition of society is also important for the rule of law, in particular that there is a need for the law to be accessible in its coherence and writing, and for the courts to be financially and practically accessible. In this, with our digitally choked lives, AI, in its proper use, may perhaps be seen to be important to the law's accessibility and so to the strengthening of the rule of law. An important and pervading consideration to the notion of the rule of law is that the law is human in its character and in its object. Law being society's relational rules and principles that govern and control all exercises of power must have a character and form that is adapted to and suited for application to the law's human task. An appreciation of this humanity of the law is central to the proper expression and to preserving its strength. Law at its very foundation is conceived and derived from values. These values inform and underpin a fair and reasonable expectation of how power should be organised, exercised and controlled at the private and public level. These values find their expression not only in the formal law, but also in societal expectations, behaviour and actions. They transcend cultural boundaries. They lie in the heart of every individual and at the heart of society as human values. They are honesty, a rejection of unfairness, an insistence on essential equality, respect for the dignity and integrity of the individual, and mercy. Each goes to the core of what we understand humanity and the individual to be, and to what is expected when power is exercised by or against individuals. Dignity lies at the foundation of self and ultimately informs the rejection of unfairness. These values find expression in the rules, principles and precepts and norms developed by society and by the law. But the nature of these values is such as to make it necessary to recognise the limits of text in their expression, drawn ultimately as they are from the human condition and the intuition and sensibility therein. They do not admit of minute definition. Words, and so what is written down, can often be inadequate to express the subtlety of human relations. The law, in its creativity and flexibility, has drawn upon these values in numerous manners and forms. The concern of public law to prevent the exercise of power which is arbitrary, capricious or unreasonable can be seen to reflect a concern with rejecting unfairness. This is the reasonable expectation of every individual, that power will not be exercised against him or her in a manner that fails to respect her or his integrity and dignity. The same can be seen in the private law, to prevent unconscionability and to deter behaviour that is antithetical to honest, reasonable and mutually beneficial relationships, in particular in commercial and even in commercial relationships. There is an important balance of values and detailed rules to be struck. Legal systems and societies cannot be built or sustained by reference only to generally expressed values. Neither, however, can they be built on a myriad of strict textually expressed rules alone. Rather, a balance will be struck of rules, principles, precepts, norms and values. A balance which recognises the requirement that rule and principle conform to moral standards as the gauge of the law's flexibility, as its avenue for growth, and in order to accommodate changes to society's changing conceptions of the application of unchanged values. The balance must also recognise the need for coherent structures of rules, the absence of which may confound law by a drift into formless sentiment and intuition. In discussing the nature of law, I've often referred in the past to an aphorism of Sir Maurice Byers, a former Commonwealth Solicitor General, who said, "The law is an expression of the whole personality and should reflect the values that sustain human societies. The extent to which those values influence the formulation of the law varies according to the nature of the particular legal rule in question." Sir Maurice was referring to the humanity of the law from which one draws an insight into legal and judicial technique, the nature of law and the content of the rule of law. Rules and textual expression of logically constructed and organised ideas are central to a coherent body of law. But where is the place of logic and of organised abstracted ideas in a personality? Taxonomy is an abstraction of the mind. It is the disembodiment of the whole into the parts and their placement into an organised logical structure. It can be seen as depersonalised abstraction, but it can also be seen as a human feature, as part of the human search for order and security. It is a way of thinking abstractedly, in particular about parts and their ordering, as opposed to thinking about the whole and its character, including its implicitness. There is much, therefore, to be said in thinking about the law of the relationship between abstraction and theoretical taxonomical ordering of the parts on the one hand, and a feeling of the human, the relationally experiential, and the contextual on the other. The humanity of the character of law, the relationship between rules and values, and the realisation that a just civil society is not based on expressed rules alone, but something more subtle and complex, are all features central to the conception of the rule of law. These features might be seen to inform and illuminate Dicey's spirit of legal freedom. Though the critical values that inform the law, the dignity of the individual and the rejection of unfairness, are conceptions, that is, abstractions. They are conceptions that are derived from emotion, sentiment, the human condition and social experience. These values come from life and experience. Thus, as important as the contrasting of rules and values is the recognition of the relationship between the abstract in its different forms and the experiential in its countless unique manifestations. It is from the experiential that the abstracted human values that sustain societies manifest themselves in concrete situations, in law and society. And so, as abstractions, gain recognition and importance in real life. It is the human and the experiential that give the proper context for the derivation of expression of rules, principles and law. And from that derivation, rules, principles and law become infused with values. I turn to these jurisprudential considerations to emphasise the need for human judgment in relation to law in so many circumstances. Logic, definition and precise taxonomy may solve many problems, but human judgment in relation to others is central. I accept that human judgment can be mimicked, at least in result, but also perhaps in a body of reasons by a machine. That's our assumption. But that is not the process of undertaking the process and making the human judgment, in particular when the judgment involves choice between two equally or more than two equally available conclusions for different reasons, as in the different conclusions of the majority and minority in Veen number 2. These considerations are easier to see in dealing with the criminal law. In criminal law, the epitome of public law, one sees the interplay and balance between rule and value, and between the abstracted expression and the experiential, the certainty in rule of liability and the intuitive synthesis of sentencing. Australia has rejected the rigid rule-based sentencing that is so prevalent in the United States. A human and societal response is called for, instinctively and intuitively formed within the framework of statutory rules. The human response dominates. The experiential and the implicit, and the importance of feeling to the human circumstance allows the court as an institution, with its experience and knowledge, to express its response as the manifestation of just state power to the inherently human, infinitely varied, often tragic and violent circumstances before it. One simply cannot reason out in logic or even describe, except by conclusions evoked from human feeling, why a sentence imposed on an offender for a violent crime is inadequate. These are all matters which have no one correct answer. The confidence in the acceptance of the one judgment comes from the recognition of the human engagement with justice to reach it. Many fields of the civil law are no different to the criminal law in this respect, though they may sometimes be less emotional. That said, Paul Finn was hearing a civil case brought by the Iranian man. The law is replete with judgments that involve the evaluation of facts, rules, principles and values about which reasonable minds can differ. The process of characterisation of facts into legal categories, a conclusion of unconscionability or lack of good faith, the reaching of an opinion about the value of property, a conclusion whether a breach of contract was fundamental or whether there has been repudiation of a contract, whether a law bears a particular constitutional character. Often such questions have no necessarily correct answer. In many ways, we have allowed our society to become mechanised and sterile with a drained sense of spirituality. There is no reason why science should necessarily have done this or be blamed for it. The machine, as the emissary undertaking the useful tasks set by the master, will or may improve or indeed even enrich the legal system. To mistake the machine for the master will lead to the end of the spirit of the law as human and free. The danger is not the machine becoming human, It is the human becoming the machine. How we embrace and usefully use machine-learned capacities to reduce the cost of justice and increase the penetration of distilled appreciation into almost impenetrable thickets of available data that we have created should be guided by an appreciation of what the law is and what the law is not. The greatest danger is not from the machine, but from the human who thinks like the machine about the law. The danger is real. Some lawyers and some judges can be heard to say that at times that text and logic form the law. For them, the machine may begin to be human, but it is they who mimic the machine by refusing to accept or appreciate that the law is not abstract logic and words alone, important though they are. It is the indefinable presence of rule, principle and value. Ultimately, it is organised societal morality. The results of the application of the law may be mimicked by a machine, but for there to be a system of justice, there must be the human process of engagement in the manner I have discussed. This may, I hope it does, say something of human consciousness, the human consciousness that allows us to recognise the deep societal and human importance of the response of the Iranian man in feeling and words, of the family at Taylor Square in feeling and sign, and of later judges contemplating Veen number 2, all embodying a sense of the presence of justice. Thank you.
Thank you for your thought-provoking words and reflection. This is the 5th year of the Sir Francis Burt Oration. The oration is a moment where we ask speakers to share their considered thoughts on present and emerging matters of interest and importance to the legal profession, particularly where the law and the profession intersect with broader society. Tonight, one of this country's finest jurists has certainly achieved that. While not famous enough in ChatGPT terms, His Honour is, of course, very famous in our world, which shows what a rarefied world it is. At this time of change and uncertainty, it was reassuring tonight to be reminded of the importance of humanity and the importance of the role of EQ in the jobs that we do and how we deal with those both within and outside our profession. On behalf of Francis Burt Chambers, may I ask you all to join me in thanking the Honourable James Allsop AC for his address. Finally, and before we adjourn for refreshments, may I express my thanks on behalf of everyone to Pauline McKay and Chantel De Silva and the staff of Francis Burt Chambers for their significant efforts in organising this event. Please will you thank them in the usual way.